Okay, welcome this evening to people who are physically here and people who might be virtually here now or maybe in the future, I don't know. My name is Tim Bailey, and I'm a lawyer in Grand Prairie here, and tonight we'll be talking about some estate planning matters and some prenuptial agreement matters. Some of those estate planning matters might include some details about powers of attorney, enduring powers of attorney, personal directives, wills, and then the prenuptial agreements at the end. If any of you have any questions, please feel free to interrupt me and we can have a discussion. My notes here don't necessarily match exactly the topic summary that you have, so forgive me if I don't go completely in order. I'll start with powers of attorney. So whenever we're doing estate planning matters with clients, we would be recommending 3 documents be done. They aren't always done, but we generally recommend them. The first is an enduring power of attorney. The second is a personal directive. And the third is a will. So we talk about those documents, we generate those documents, and people will often sign those documents with us. In addition to us taking in information to get a sense of people's financial lives, and giving advice based on people's specific situations. So an enduring power of attorney is a document that that people sign, let's say today, appointing, in this document we call them an attorney, but they're not, that doesn't necessarily mean they're a lawyer. That could be their spouse, that could be their child, that could be their friend. The attorney is a person who takes charge of their financial matters, makes decisions of financial natures for them, signs documents relating to finances and property. In the event that they either don't want to make those decisions by themselves or that they are incapable of making those decisions or signing those documents for themselves. So the first question I guess I might have posed on the outline is whether or not everyone or anyone needs a power of attorney. And the simple answer is no, not everybody needs a power of attorney. Even people who prepare and sign powers of attorney may never need them because generally, well, I guess I'm going to jump around and I'll explain a power of attorney versus an enduring power of attorney. So, or rather a springing power of attorney. A power of attorney, we'll call it an immediate power of attorney, takes effect immediately upon its being signed. So if you signed this document today and you appointed Jeff as your attorney, then as of the signing of that document, Jeff would be able to make decisions of a financial nature for you and be able to sign financial documents for you. That's an immediate power of attorney. A springing power of attorney doesn't come into effect until a certain event in time. Normally, that event would be on your mental incapacity, or more specifically, somebody who's qualified to give an opinion as to your mental capacity gives an opinion or a declaration that you no longer have the mental capacity to make decisions of a financial nature or decisions that relate to your land or other property. So it's possible that you might never need a power of attorney because you never lose your mental capacity before you die. Because, of course, these documents would only have effect while you're alive. Where the will takes effect after you die, the power of attorney and personal directive take effect while you're still alive, but when you lack the mental capacity to make those decisions. So you might die unexpectedly and instantly, as opposed to losing your mental capacity first for a certain period of time, several years, and then dying. So, to answer the first question, simple answer, no. Not everybody necessarily needs one, or they might never use it even if they have it. Yes, Jeff? Mm-hmm.
I don't have a document. She loses her ability to
Mm-hmm. So sometimes nothing, and then no decisions are made until the point of her death or after. But if somebody needs to make a decision or assets need to be liquidated if share prices are falling, what have you, and somebody needs to make a decision, there's no power of attorney, nobody's been pre-appointed to make those decisions, then an interested party, that's a term under the Powers of Attorney Act in Alberta, could make an application to the court for an order for trusteeship, to become the trustee of that grandmother, trustee of her assets. That, yeah. So it can take a while. It can take a year. Or, if you're lucky and you know the avenues to take, you might be able to get an expedited process or a judge who's willing to hear the application. You might get it in a month or two. Yeah, it can be difficult. Of course, you need doctors' opinions, so you're going for those opinions. Meanwhile, share values are continuing to drop, or house prices are dropping, or maybe she needs the money for a procedure. I don't know. I mean, in Canada, we're fairly lucky that way. Lucky in the sense that we don't have to pay for it, but we have to wait for it. So it would be going for that court application. You have to put the Office of the Public Trustee on notice of the application, and usually there's some stick handling that you have to go through in order to convince them that they should not be questioning the application and they should not be intervening in the application. You have to put all the paperwork together, which is fairly intense. I mean, I've got one that where I think the client came to us in August or September, and then we put a whole bunch of work back on the client because there's sort of 4 pages worth of, we need this, 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 and then they have to go and do the homework. And I mean, we still haven't heard back from that client. So some of it is court delay, some of it is lawyer delay, and some of it is there's a lot of information you have to gather. Yeah. You're not wrong. You're not wrong. Yeah, and compared to the cost of the application that we make to the court, I mean, we might charge $2,500 to make the application, plus the court filing fee and any other disbursements, but the power of attorney itself, if it's pre-written and done properly and signed ahead of time, then one document is probably $250, so a tenth of the cost, and it's there if you need it. And it's not going to take 12 months waiting for that process, right? Any other questions right now on that? Yeah, no, I gave you the cost. Okay. So earlier I explained the difference between an immediate and a springing power of attorney. I'll go back to power of attorney versus an enduring power of attorney. That's just some more language, just some more terms. The enduring power of attorney, so if this is a timeline, and we have today, and then we have incapacity, here, then we have death. So the immediate power of attorney would take effect immediately and stop here unless it is an immediate and enduring power of attorney, because the enduring term talks about enduring or continuing after the moment of incapacity. So sometimes we have an immediate, spelling is not my strong point here. Spelling on a chalkboard or a whiteboard is hard. Way harder than on a page when nobody's watching you. Immediate. Hopefully that's right. So an immediate power of attorney, enduring, /springing. So the majority of powers of attorney that we do, they're a springing, enduring power of attorney because they spring into effect on the moment of incapacity or on the moment that a doctor declares you incapacitated. They spring in and they endure past that incapacity. So these are the ones that we're doing most often. Sometimes we do these if, actually, probably the most often I see these, and I don't see them a lot, it's when people are going on missions trips. They're going to Africa or South America, and they need somebody to look after their stuff. I need mom or dad, or I need son or daughter to look after my house and my this and that, and maybe renew my mortgage or whatever while I'm out of the country for 5 years. So often we're doing these, and funnily, strangely, we're often doing them at the 11th hour, like the day before they get on the plane. Okay, any questions about immediate, enduring, springing, those terms? No? Okay. Yep. Yeah, because in that immediate power of attorney, or even in these ones here, there's always a clause. Whether or not there was a clause, the legislation would say that if you still have capacity to do so, you can revoke these at any time. You just revoke them in writing, or you tear them up, or you burn them, or But you're right. You don't want to forget that you've sent out 5 different powers of attorney to different people, and then all your stuff's gone. Chances are, if you've appointed somebody, hopefully they're trustworthy. Okay, so we talked about immediate versus springing. What is required for the springing power of attorney to come into effect? Normally, the legislation says you need at least one person to be the person who determines when you have lost capacity. So in the document itself, you could say, Jones is the guy who gets to decide when I'm crazy. okay? That's what the legislation says. I can pick anybody. Or I can pick nobody, and the default is going to be that it's going to be one service provider, and a service provider is defined under the legislation as, I don't think I have it here, but effectively it's a physician or a psychiatrist, declaring in writing that you no longer have the mental capacity to make decisions of a financial nature. Do you guys have on your outline there the question, do you need a lawyer? Aha, perfect. So the answer is no. But I will say that generally it's recommended because nobody ever forces me to hire a plumber to do plumbing. And sometimes, when I've done my own plumbing, I've made terrible mistakes. Plumbing's a bad one because usually what happens is you fix the plumbing and you test it and it's fine. And then you put the drywall back. And then a week later it leaks. Then you have to rip all that out. And mudding and taping is not fun. So no, you don't need a lawyer. You can go probably on the internet and you can probably go to the license center and get a kit or whatever. But if you actually want it to work properly when you need it, then the investment in hiring a lawyer to do it properly, who also has a professional insurance policy backing him or her in the event that they make a mistake, probably worth the investment. Yeah.
You want a lawyer.
Right.
He's there to speak. When I had very nervous. When you do this, the person has to be of sound mind to sign all of it.
Mm-hmm.
Usually as a family member, you only think of doing it, starting to have trouble.
Right.
And then you come in and you're really nervous. Someone's going to look at you. Usually lawyers, what I found, you've got a series of questions you'll ask.
Mm-hmm.
You'll ask me to step outside of the office.
Right, to make sure there's no undue influence. Because there's a whole host of ways that people can challenge the documents, whether it's raising the question of whether or not the person had capacity to do it, whether or not they were being unduly influenced, whether they were under any delusions or delirium. There's a number of ways that you can attack the document. But you do them, hopefully you do them in a lawyer's office. And everybody's going to be different. Have I got a checklist that I go down and check at this point in my practice? No. But I'm casually asking questions that will lead me to a determination as to whether or not an individual has capacity. If there are any questions in my mind, then I will have the individual conduct a clock test, which is an interesting one. So I draw a circle on the page and say, please put the numbers in the clock in the circle to make it look like a clock and show me the time 10 past 11. And seems like a simple thing to do, but there's actually a lot of things that go into it. So there's pre-planning, right? Spatial awareness, because sometimes, well, not sometimes, I shouldn't say sometimes because it sounds like this happens often. But, I've seen this. Okay? But, if I see this, 12, okay, well, that's some planning, right? And then, okay, we can fill in the others. And even the way the question is posed, 10 past 11, has a good reason for it. Because if somebody is lacking capacity, they're going to hear the number 10, and they're going to be drawn to it. So quite often, in cases where somebody might be lacking capacity, they might choose these as opposed to this. And I didn't make that up. That's from cognitive psychologists who've done courses for lawyers to say, this is actually a half-decent way of figuring out whether or not somebody actually is having problems here, because I don't really know this, but the psychologists say that we would be surprised who's sort of out there walking, talking, carrying on conversations, may have all the social graces that you and I do, but there are certain things that just aren't connecting inside. And these are some ways to suss those out. Got me off topic, Jeff, but still on topic, so thank you. So what problems might occur after a power of attorney takes effect? So in this case, I'm going to talk about an enduring or a springing power of attorney. The individual has lost capacity. There's certainly opportunity for abuse to occur. I've seen that happen. I've seen situations where money and property have been misappropriated, mishandled. That's not good. How do we safeguard against that? We can appoint multiple attorneys requiring multiple signatures and consent. I don't really like that, because I've also seen problems where if you have 2 or more attorneys, or 2 or more executors, or 2 or more agents under a personal directive, that it can be difficult to get a decision, to take any action. So you can be at a standstill if you don't have unanimity, and then you're going to court for an order as to how to proceed, and that's never good. It's tough, but I think really what you're trying to do when you're preparing a document is you're trying to appoint the person that you have the most faith in this world, and in whom you can place the greatest amount of trust. And then hope for the best, I guess. Maybe that's not a comforting word of advice, but I just don't like seeing multiple attorneys, because it does create roadblocks. Another issue I see sometimes is that third parties might not recognize the power of attorney as being valid and enforceable. And it happens more often than you might think, where there's an investment brokerage that is refusing to take instructions from the named attorney. There's a doctor's declaration saying this person lacks capacity. You have the original power of attorney. You take it to the investment broker, and they say, sorry, our internal policies say that we can't use this, or my supervisor says I can't use this, so how do we get these things sold? How do we get these stocks purchased or sold? Why does that happen? I think probably just because there's maybe a lack of understanding on the part of that individual person at that institution. They don't want the risk. They don't want to take the risk. Which is funny because there's risk if they refuse to do it. You know, I want to sell these stocks because I think they're going to lose value tomorrow. I'm sorry, we don't recognize this document. Well, then they're potentially on the hook for your investment losses when you actually were trying to give them an order to sell that day. But they seem to be erring often on the side of what they see as caution in not using or not recognizing the document because they don't want that other person to come back and say, well, why are you selling my stuff? Because I'm still of sound mind. Or maybe they suspect that there's an issue of elder abuse or I don't know what. Interestingly, with banks, I've dealt regularly and extensively with banks here in Grand Prairie for 15 years. And there's a continuous cycle of employees going through. And whether it's they're jumping ship to another bank, or whether it's because they're just in Grand Prairie and Grand Prairie is a stepping stone and they want to get back to Edmonton or go to Calgary. So it's almost like you're dealing with a person who's relatively new every couple of years. So they don't seem to necessarily understand the document. But what do we do about that? Well, I get a call and we write a letter and hopefully it fixes things. So we tell the bank, yes, the document's valid. Why aren't you recognizing it? Okay? We're going to jump to appointed attorney's liability. So there's nothing in Alberta that requires an attorney, again, not a lawyer, but your spouse, your cousin, your friend that you've named as the attorney under the power of attorney. There's nothing in Alberta that requires them to consent to the document at the time you sign it. So you don't even have to tell them that you've named them, which might come as a surprise to them in the event that you lose capacity and then somebody calls you up and says, hey, we need this done, and you're named on it. Up until the point when you actually agree to do something under the authority of that document, you don't actually have to do anything. So you could say, sorry, thank you, I'm so honored, but I'm going to renounce my appointment. I'm not going to take any steps. I'm not going to do any of this work for whatever reason. But once the person takes a step and takes charge and does any action under the authority of that document, then they must continue until such time as they themselves die, they lose their own mental capacity, the person they're doing the work for dies, because then the power of attorney ceases to have effect, or the court orders that they may step back and cease any further activity. So once you take on that role, you have to continue it. You have to finish it, unless any of those other events occur. So it's akin to a trusteeship role, and there's a high amount of trust and obligation and responsibility placed on that individual. I know, Alan, in sermons you've talked about trusts, right? And So a trust, I don't know if everybody knows what a trust is, but a trust is, I've got this thing, and I own it, and I have legal title to it. Let's call it a house, okay? So I don't feel like having it in my name anymore, but I still want to have the benefit of it. So I'm going to take this house, and I'm going to put it in Ed's name. Ed's going to have legal title to that house. The condition of me transferring it to Ed is that he holds it in trust for my benefit. At any point in time, and I'm just making up the terms of this trust right now, at any moment in time, I can say to Ed, please transfer that back to me. So Ed holds that in trust for my benefit. High obligation is placed on Ed. He has to make sure that that house is insured, is well maintained, so on and so forth. So same thing when you have an attorney under a power of attorney or a trustee under a trusteeship order. They're liable for their negligence. Okay, so if they cause a huge amount of loss to that property, they can be held liable to that. But what they should be doing is they should be getting advice about what to do with that property, and they should be acting in a prudent manner, similar to that of a prudent investor or a prudent homeowner. And as long as they're doing that, they're not going to be held liable to just normal losses that anybody else would have incurred if they were in the same position. Yes?
A lot of fighting going on in the family.
Mm-hmm.
If you agree to be the attorney, buy insurance for yourself?
You can get a bond. Yeah, you can buy insurance. Usually normal insurance companies do not deal in this, but if you go to Lloyd's of London or whatever, there are larger underwriters that will deal in bonds. Yeah.
You can do two. So before you agree to this,
Yep. Yep. That's right. And we've seen some messy ones, and we've seen huge accounting fees. We've seen huge legal fees over the course of sometimes 5, sometimes 10 years, depending on who's involved and what's at stake and how disagreeable they are. Yeah. And if you're in the middle of that, if you're the one holding all the stuff, you almost know that you're going to get, well, you're in the middle of the litigation, which is hard enough, but very likely at the end of the day, once you've spent all the money on legal fees and accounting fees and expert witnesses and this and that, and there's much less to go around, then there's probably either a part of that same lawsuit or another lawsuit coming at the executor or the attorney under the power of attorney. Yeah, so you have to consider whether or not, yes, I will do this. And most people say yes. And yeah. Yeah. Well, and I'll jump ahead as well because later on, I think under the executor heading, I try and answer the question of who you should appoint as your executor. And the same question could be asked, who should you appoint as your attorney? And normally it's somebody who's trustworthy and has a decent handle on numbers and finances. Hopefully they're a good communicator, because one of the biggest problems I see in estate litigation is that people aren't talking, and they're not sharing that information with beneficiaries or other interested parties. And I find that silence breeds suspicion, right? I mean, if you got it doesn't matter if it's a $100,000 estate or a several $1,000,000 estate, it's been 18 months, what's happening? Like, let's set a regular date every month and have an update. That's the day on which the executor updates the beneficiaries. And sometimes the update can be, there's no update, or I'm waiting on the stinking lawyers and they're taking so long. Blame it on us, that's what we're for, right? But another consideration as to who to appoint, I never know whom to appoint as an executor, is whether or not you should appoint an individual or a corporate executor or corporate trustee. Because all the banks have branches, I shouldn't say branches because that's confusing, arms or related entities that will, for a fee, administer an estate. And if you've got 5 kids who you know are going to battle it out over the family farm and lose half of it in the process, and lose 10 years of their lives and get a whole bunch of gray hair or a lot of bald spots, then I think a lot of times that dispute goes away if none of them are in charge. Because I guess the will could still be unequal, so that could still be an issue. But I find a lot of the problems are, what are you doing? I don't want so-and-so to be in charge. I don't, So. All right, I got out of sync here. I'm gonna go on to personal directives now, but any questions about powers of attorney? No, okay. So, personal directives, similar to powers of attorney, generally take effect while you are still alive but lack mental capacity to make decisions of a personal nature. And normally we say that means healthcare. Healthcare, where you live, who you hang out with, those kinds of things. Now, we don't get into this kind of immediate versus springing and enduring when we're talking about a personal directive. And I think the reason is because you are always kind of traveling with your own body, right? I mean, you don't need an immediate personal directive. When you have capacity, why would I say that, okay, no, I want Alan to make my healthcare decisions for me? Alan's going to say, well, why? It's not like I'm traveling to Tanzania and over there I need Alan to make decisions about my healthcare because my healthcare is with me all the time. So we don't have to worry about immediate. But they are they're springing and enduring, if you wanted to use those terms as well. So they spring into effect. Again, the legislation talks about being able to appoint anybody, any individual, to make the determination as to when you lose capacity. But almost invariably, people choose to say, I want it to be a doctor. One doctor can sign a declaration. So that's how they come into effect. The question here is, does anyone need one or does everyone need one? Same answer to that question for the power of attorney. No, you don't need one necessarily. You don't have to do one. And sometimes you will never actually live in a scenario where you would have needed one, or if you didn't have one, where somebody would have needed to do a court application for an order, a guardianship order. So when it's healthcare, it's a guardianship order. When it's money and property, it's a trusteeship order. So answer is no, you don't need one, but it's pretty cost effective to do it ahead of time. Again, same answer to life insurance. You need life insurance? Well, I don't know, like lots of people never actually get a payout because they live to a point when they're no longer covered. But most people get it because they'd rather have it if they actually needed it. Yep.
I had a friend of mine, his mom's whether it's full applaud or not full applaud. Can't talk that over with your mom 2 in the morning. She's out of it.
Right.
So this document is wonderful to say, put it ahead of time. Here's what we're going to do.
Absolutely. So, so I encourage my clients to have that discussion with whomever they're appointing at the time that we're doing the documents, right? Have that heart to heart. This is what I'd like. I've seen some personal directives that are extremely specific. So, like my document that I normally do is about, I don't know, 3 pages long. And it basically says, this is the person I appoint, this is the alternate. These are the general topics of authority that they have for making decisions, like healthcare, accommodation, who I hang out with, what kind of social activities I engage in. If you're in a coma, you're probably not doing a lot of social activities or educational or employment, but all of those are covered under the legislation in the Personal Directives Act. So again, my document is fairly short. It says that, and then it says, in the event that I lack capacity and have some kind of terminal illness, chronic illness, I've got deteriorating capacity, it's not going to come back up in the opinion of the service providers and the opinion of the doctors, then the instructions are keep me comfortable, free from pain, but don't keep me alive forever. So fairly broad versus I've seen other documents occasionally that are extremely specific. So in this case, I want to be fed by intubation. In this case, I want to receive some life-saving attempts, but not all. And I've looked at those documents, and I can kind of understand why people are interested in going that way, but I find that without a crystal ball, there's so many different combinations that we cannot predict that I find the biggest and most important decision that you should make is who you trust the most to make the decisions in your absence, right? That's the way I look at it anyway. People don't have to agree, but I generally think, for me, I appoint my wife, and alternatively, I appoint my friend, whom I trust, and with whom I've had these discussions either many times or at least once. So they should know what to do in that case. Yep.
Someone has some alphabet. Okay, I want euthanasia. How do you know which ones that are enforceable and others that, yes, you've got that?
Sorry, how do I deal with situations that are illegal? The client who is making the document or the attorney who is trying to? Oh, Okay, so then,
You sit there and then say, well, that's not legal. It has to be a legal.
right, so I could say, you can write whatever you want, but why would you write something that is going to be unenforceable? So, and with respect to the, I guess, well, what do we call it? Assisted death? Is that what we call it? As far as I'm aware, there are strict rules in place, at least for the time being, that require that you have capacity before you make that decision. And it can't be done in one of these documents, in a personal directive. Like, you have to pretty well have capacity up until the moment of the death. So you cannot, at least for now, you cannot put that in a personal directive. It's not enforceable. But yeah, for other possible, well, I'll give you another example of things that might be either unenforceable or illegal, and they would. So in the circumstance of a will, where maybe we've got a blended family. So whatever, hypothetical, man comes in and says, I want to make a will. I like my wife, but I don't want to give her anything. I want it all to go to my kids that I had before I met her. Okay, sir, well, that's great, because we all want some things, but we can't always have the things that we want. And in your case, you have certain, unless you've got a prenup that says otherwise, the law is going to say that you need to provide for your spouse. So I can write any document you want, but if it's unenforceable, why would we do it? And I'm not going to do it in the first place because somebody is going to look at it after the fact and say that I was negligent because I didn't give you the proper advice to tell you that, sorry, well, you actually should have provided for your, is this thing on my, yeah, you should have provided for your wife, and because you didn't, then there's a big estate litigation, and your estate lost half its value because I didn't do my job. So that's one of the ways that I would tell my clients that they shouldn't do something that the law is going to tell them they shouldn't have done.
Tim, I think a few years ago, there was a bit of a push. I think when everyone was trying to get the law changed or encourage people to get personal directions, because there was a situation where a husband became incapacitated.
Mm-hmm.
So he was married, and then they passed over a home. Then they had another house, which they rented to their daughter, below market.
Right. Yep.
So this guy became incapacitated, didn't have the personal direction, so then the government became his trustee.
Could have been the public trustee's office, which is part of the Alberta government. Yep.
So then they said, okay, our job is to do the best for our et cetera, et cetera.
Right.
Best bang for the buck. So number one, this rent over here isn't enough. You're either going to charge the market rent. As a matter of fact, what we'd really like you to do is to sell that house because we want that money because we're going to move your husband to the other end of the province because cost effectiveness is better for his needs. We're moving him back. Thank you very much. That's what we do.
And please pay us the 2 years of back rent that you didn't pay for.
All this stuff.
Probably.
So they were saying that this was the law, that the trustee or whichever guy is going on, their job is only to be responsible for the person that pays.
Yep.
In his interest.
Yep.
So
Yep.
we understand, yeah, he probably would be happy with his daughter, but our job is to look after him. this is what we do. You know.
Yeah.
Did they change that law, or is it still like that?
So the public trustee, you're right, the public trustee is still required to act only in the best interests of the person whose estate they are looking after. Okay? And I say estate, they're still alive, but they're financial assets. Yeah. So no, they haven't changed it. It still operates the same way. Yep. Yep. Yeah.
What if his wife says, no, don't drive with me, I don't want that. But, right, like, what,
Yeah.
in real life,
So sometimes it plays out in a way where they don't ever see the document because things happen so quickly. I know they have a green sleeve program with a lot of seniors in care facilities where I think whether it's on the fridge or whether it's on their door, I don't know, in a little folder, it's this green sleeve and it says, this is what I want. I've got my do not resuscitate here. I've got my power of attorney. I've got my personal directive. So that's one way that the system is trying to identify where those things are. In other jurisdictions, there are registries, public registries, where if you do a personal directive, you register it. People can't actually see the document, but the system can look it up and say, okay, well, they've got that, and this is the person named. This is their contact, so let's call that. I think Alberta might have a voluntary registry system now, whereas I think BC is actually like a requirement. But I don't know anybody who has used it. Yeah. Right. Yeah. Yeah, exactly. Yeah, it makes sense to me. So we're the two smart people around. But you're right, because I mean, like, if the two of you did documents and you named each other, right? But then you're in a car accident, and maybe one of you dies and one of you is still alive, but you named an alternate in Florida, who knows? Who knows about that, right? Yeah. Yeah. Mm-hmm. Mm-hmm. Yeah. Yeah. Yeah, fair enough. And so maybe, yeah, that goes back to my comments about the banks and not trusting them, right? Yeah. 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 Right. Yeah. Yeah, if it takes a few days or a week or 2 weeks and that, yeah. Yeah. No, good comment and question. So what problems tend to occur after personal directives take effect? So I've seen situations where talked about this about the powers of attorney, multiple agents under the personal directive have been appointed and they can't agree on the action that needs to be taken at that time. So then nothing happens. until a court order is sought and obtained. So that can be a problem. I've also seen situations where, let's say one child has been appointed, another child has not been appointed. Dad is elderly, obviously has lost capacity, so now the document is in effect. Everything goes hunky-dory for a while, and then somebody intervenes, somebody who's not part of the family, somebody who has befriended the elderly fellow. I mean, this was a case that I had, and the third party was intervening in an inappropriate way. And there was years of litigation that ensued, and then brother took side of third party and made things more difficult. Parties spent 15%, 20% of a fairly significant estate, even before dad had passed away, but the money wasn't the big thing. Third party convinced dad to disown certain people in his family, including grandchildren and so on and so forth, and had photos of third party's grandchildren on his fridge. So I don't know how those things start to happen, but for whatever reason, we live in a world of hopefully well-meaning people, sometimes busybodies, who can cause problems in these situations, and you think you actually have a document that can give you the authority to manage things. But I always say, I mean, anybody can be sued at any time by anyone for anything. Like anybody can take you to court. And at that point, you have to either roll over or you have to defend yourself. And unfortunately, in a case like that, I mean, third party takes well-meaning daughter to court, and everybody loses a lot of sanity and money and sleep over it. So it's not a perfect system. You don't have, perfect guarantees that you're going to be able to do the things that you think you've been appointed to do. But it's the system we have, and I think doing the documents is still probably better than not. What time do we have there, Alan? And after 8. And we started at, we were gonna start at 7, weren't we, Chris? Okay, so what do you guys have next on your summary there? Is it the wills and estate plan there? Okay. So when we talk about wills, we talk about a document that takes effect when you die, not when you are still alive but lack capacity. Those were the other documents. Okay, so in a will, we usually appoint an executor if we've done it right. I'll go into that in a minute. We often appoint a guardian of minor children if we have minor children or we anticipate having minor children in the future. I'll call this executor and trustee. then we instruct our executor to pay all of our legally enforceable debts. Because when we die, so if before we died, we owed money to people, and then we die, we don't magically make those debts disappear. We still owe those people that same money. It's just that now it's our estate that owes the money. So pay debts, and then distribute the residue, the rest of the estate. That's usually in the first 3 pages of the document. And then we might have 10 more pages with boilerplate powers that we give the executor and trustee to give them the flexibility they might need in any crystal ball scenario, hopefully. We give them a broad range of powers and authority to deal with simple estates and complex estates. So an executor in a will is the person that you would appoint to take care of your financial life after you die. They are supposed to execute the terms of your will, carry out the terms of your will. If the executor is also the trustee, and you could actually name separate people as executor and trustee, but almost always the executor is the trustee. If the executor is the trustee in your will, then that executor takes legal possession of your assets, of all of them, and holds them in the for the benefit of the creditors of your estate and the beneficiaries, assuming your estate is not insolvent. Okay? Just briefly, when would we have a situation where the executor was not the same person as a trustee? Sometimes in larger and more complex estates, maybe we are creating separate trusts. Maybe there's a blended family and we've got a spousal trust where we're going to leave the spouse $500,000 and she gets, and that's to be invested while she's alive, and she gets the revenue or the income from that trust for as long as she lives, and then when she dies, that $500,000 goes back into the residue of the estate and is distributed maybe to the other kids by the executor. What are some characteristics that a good executor might exhibit to help you determine who you might appoint? Hopefully you appoint somebody who's likely to outlive you. So maybe not a great idea if you're in good health to appoint your grandparents. Hopefully they are trustworthy, you would think, if you were going to appoint them. Fair. I touched on this earlier, but a good communicator, very important, to be able to communicate with all interested parties, whether they be creditors, whether they be guardians of minor children or grandchildren who might become entitled to the estate, communicate with the beneficiaries, but also third parties. It can be a big job being appointed an executor and carrying out those duties, calling in all the assets, identifying, securing them, making sure there's insurance on houses and vehicles, and that you've inherited a whole new financial life. I mean, we have a hard enough time, my wife and I, figuring out just our financial life, right? And keeping everything under control. We haven't inherited another person's financial life yet. So it's a big job, and it varies depending on the estate. Yep. I think that if, what do I think? I think it's a job that has to be done by somebody, right? And so if I've been asked to be an executor, and I've been asked a number of times, clients sometimes ask, and we routinely say no, unless it's, unless we have a very significant relationship with that person outside of the office, we'll say no. It's a job that somebody has to do. So I could say, am I more, and this is not a comment on you or your question necessarily, but am I more fearful of the risk and the work than I am a friend to this person, or a brother or a son to this person? Somebody has to do the job, right? But you're right. I mean, it could be a bloody mess. And so you might think twice if you know that person is into 8 different businesses and owns land with this strange person that you don't trust, or whatever. I mean, I don't know. I mean, probably you have some idea. If that person is close enough to you that they're going to ask you to do that job, I mean, hopefully you know something about their financial life. But if you don't, sure, ask. Say, you know what? I've been thinking about it. I heard this seminar from this crazy lawyer. He said it was a big job. He said it can be really messy and litigation all over the place. You mind if we have coffee and you can tell me a little bit about your situation so I know what I might be getting into? Or like, where do I find the stuff? Like, do you have a desk? Do you have a special drawer? Like, so yeah, maybe not. It might not be a bad idea to get some more information before saying yes. Yep. 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 Sure. Right. Yep. For sure. Yeah. Yeah, absolutely. And we, when we open up an estate planning file for a client, we send out a questionnaire. And it's 10, 12 pages of, oh my goodness, this is my financial life, and these are my bank accounts, and this is my RRSP, and this is my RIF, and this is my this and that. I guess you wouldn't have RRSP and RIF at the same time probably. But this is my house, and this is my mortgage, and these are my kids, and yeah. Yeah.
Here again, if in their property was clean on the
Yep.
family, someone dies without
Mm-hmm. I'm going to write a strange word here. Intestacy. They've died intestate, meaning without a will. There are provisions under the Wills and Succession Act of Alberta that dictate who can apply for a grant of, it's not going to be probate because there's no will, but it'll be a grant of administration. Who gets to administer the estate? And there's a whole list of priorities of who has priority to make this application, depending on the circumstances. So, spouse, children, parents. So if you don't have a spouse or children, then parents. If you don't have spouse or children or parents, then it's siblings. But if you got 10 siblings, it's all of the siblings. So,
big estate, people, maybe years
So depends on the characters involved. Yes, definitely could. But it can happen over here too. Yep. Yes.
The other one, if you're, you care about the kid,
Yep.
you should have a will. If you don't, you set them up.
Yes. And you're right. But I still say it's better, but it's not a guarantee. Because I've seen terrible fights where there's a will as well. And so I think that don't have children with bad character. Go ahead.
The other thing I've been in the cases, it's always gone to probate. Probate goes through the judge.
Yes.
He fixes it. I can keep it.
Yep. So people will often hear the word probate and say, oh, probate. It's a terrible thing. We're supposed to avoid that, right? At all costs. Well, not if you're the executor, because probate is the administrative process by which the judge confirms that that is the last valid will and testament of the deceased, and that that person has the right to administer the will according to its terms, and the authority to do it, so go ahead. So that it's actually protecting you in case 2 years down the road somebody finds another will that was actually made later and was valid, and you already got rid of all the stuff under that will. Whew, good thing you got probate, right? But people see probate as this scary thing that costs a lot of money, and it can. But quite often it needs to happen if you've got certain types of assets or categories of assets in your estate. It has to happen. And sometimes should happen if it's a scenario where you think there might be some conflict. Or if you just don't know what's out there. We don't know if there's another will. If you're not closely related to that person, you might not know how many times they went to 5 different lawyers' offices in different cities making new wills.
At the end of the day, being unless there's people they can find, give the property to, government gets it.
At the very end, yes. So there's a long list of people to whom the property will be given. So starting with spouse and children and parents and siblings and parentalic descendants, so cousins. I mean, yeah, you have to be without family before it goes to the government. But it's possible. It's possible. Yeah. I don't want to talk my way out of future work or a job here, but it's a fairly comprehensive system under the intestate provisions of the Wills and Succession Act. But you don't get to control it. And if you're okay with that, and if you're okay with leaving people with a potential mess and uncertainty, because again, like, I know that there's a system, but not everybody knows that there's a system. I know what the system is, not everybody necessarily knows it. So when your family knows there's a will, oh, okay, good. Wait, what does it say? Am I in it? At least there's a sense of certainty, right? And at least there's like, okay, mom or dad set out their wishes. This is what we need to do. Yeah.
When they went through the whole
Mhm.
So it turns out that they found him and his mother were both rolled over in their graves believing that he got the money. Him was getting everything, the whole everything, his entire estate, his house. He didn't put anything up, no nothing. And so it was like, you can't control it. It's the worst case scenario for him ever. Because it was like a big fight between them.
Because of one crazy night.
And then
Yeah.
now this
Yeah. Yeah. It's like Jerry Springer. Oh no. Yeah. Yeah. Yeah, and don't get me wrong. I mean, you're right. I recommend having a will over not having one. I'm just trying to answer your question completely. Yeah, I regularly, this isn't going to make anybody feel good, but I regularly write off a bunch of time when I'm doing estate planning because my regular hourly rate is high enough now that I can't, I have to still put the time in, right? Because the clients need it to happen. But for the fees that we charge for, and we're usually doing power of attorney, personal directive, and a will for a couple. That's what we most regularly see. Whatever, $950 or something for 6 documents. But I can't make my hourly rate. So I'm, often $1,200, $1,300, $1,400, and I'm cutting it down because I need to give that value, right? So yeah, cheap and whether you have assets, net assets of $50,000, $100,000, $20 million, pretty good investment for the peace of mind. How many executors should you appoint? Again, I don't often recommend appointing more than one. You can have alternates in the event something happens to the one, and then this person is trying, and if something happens to both of them before you die, then maybe a second alternate. But those are my general recommendations without knowing the personalities or the characters involved. So I'm happy to be overruled, or I'm happy to have my advice not listened to by a client who knows their own family and says, no, these people are not going to fight. They know that? Great, I don't know them. But I've seen too many scenarios where you've got multiple executors and they either can't get anything done because they don't agree, or they can't get anything done because I've actually got one where one's in somewhere in South America. And it's actually, that one is not my client. We've got 3 executors on this estate. And I've got one of them here. There's another one here who's using another lawyer, and the third one uses the same lawyer as the other person, but that third one is in, I don't even know, in the jungle somewhere where they don't have lawyers or telephones. So, and this has been 5 years, and we don't have probate yet. So, one example of why you might want to appoint somebody in the jurisdiction, which is probably got a recommendation here. Oh yeah. Oh, going back to characteristics of a good executor, I say proximity, not too far away. Makes it more difficult even if they're in another jurisdiction, another province, There are other rules. They have to get a bond. They have to get an insurance policy to cover them in case they run away with all the stuff and the Alberta courts can't find them. But worse, if they're cross-border internationally, there's other potential tax laws that come into play that I don't have the expertise to speak on, but I know that the consequences can be disastrous. Because when you have an executor in another country, like I was talking about the trusts where Ed was holding my house in trust, he's the trustee. Well, actually, if he holds my money and my other stuff as well in trust, he's my executor, all that stuff is domiciled. The trust is domiciled wherever it lives, wherever Ed lives. So if he's in the United States and my net value is over, I don't know what the rule is now, $2 million or something like that, then all of a sudden the US government starts looking at my entire estate and starts taxing my entire estate in addition to me having capital gains tax here. So it can be, don't quote me on that, internet. There's some tax lawyer who will tell me I'm wrong, but it can be bad. Okay? I usually say one executor and alternates, not multiple co-executors, but again, happy to be challenged on that or overruled by my clients. Friend versus family, I don't think it matters, as long as they meet the characteristics of a good executor, and as long as we think that the family is not going to fight. Because I think if the family is going to fight, you almost don't want family. You almost want that corporate trustee or executor to take away the element of contest between beneficiary and executor. Should the executor be the same person as the guardian for your minor kids? That's a question that I get often. I say it depends. You don't want to appoint an executor who's really good at looking after children and has the same parental values as you do if they suck at finances. That's a legal term. You could take that to the bank. Conversely, you don't want somebody looking after your children who might be a financial whiz but hates kids. This doesn't make sense. Some people say, you know what, I want the guardian to have easy access to the money, so wouldn't I make them the same person? Well, yes, if they both meet the criteria that's required by each station. Other people say, I want checks and balances, right? If this guardian is looking after my kids and they hold all the money, won't they have the temptation to use that money for the kids' benefit, to buy themselves a fancy home? Well, I don't know, maybe. But maybe you should think about that. As long as I'm hoping that you're going to appoint somebody who's trustworthy to look after your kids and trustworthy to look after your money. Again, as long as they're trustworthy and they meet the qualifications for each independent station, then who cares? Whether they're the same or separate, that will be up to you. Questions about that? Okay, so already kind of talked about corporate trustee. They charge fees, like I said. They can seem expensive, however, and usually what happens is you're required to appoint them, of course, up front, and sign a contract with them in relation to their fees. Yep. Yeah. Yeah.
Are they in conflict?
The internet is watching my answer.
They can be really outrageous. I mean, we had to deal with a bank that I thought.
Yeah.
I just don't like the idea that they run law.
Thank you. I'm glad you have that opinion. Yes, I'm starting to see that. I'm starting to see trust companies that are arms of different banks come in and say, "Hey, can you refer refer clients to us?" And then I'm looking at the tasks that they're doing and proposing to charge money for, and I think, "Hey, wait, isn't that my job? I feel like that's my job." Yes, they are starting to do that. Is it right? I don't know. There's a piece of legislation in Alberta called the Legal Professions Act, which actually makes it illegal for anybody who's not a lawyer to perform legal services. So eventually, some lawyer somewhere might get annoyed enough to report them to the authorities for doing something that's not appropriate.
They seem to get into new businesses. The other thing I just discovered, I had to give money back and forth. Because I couldn't do it, major Australian thing. I went to the Treasury Bank, got told you can't take an Australian check. And then I got told that your solution is Western Union. It's wonderful. And then I discovered
Who owns Western Union?
Australian banks bought into Western Union.
Yeah.
And all the Canadian banks are saying, yay, Western Union, you should use them.
Yeah.
Well, good luck. Wait till you see these great fees.
Yeah.
And guess who owns them?
Mm-hmm.
So all of a sudden, they can't do a service they've done it for years.
Yep. Yeah. No, and you know what? Banks, I use banks. They hold my money. I borrow money from them. But I often say that banks are not dumb, and banks are running very profitable businesses. Banks have been taking our money for a long time, and they know how to do it. Banks generally have the tallest buildings, their names on the tallest buildings in the cities, along with insurance companies, and to a lesser extent, in some very specific cities, oil companies might have their names on tall buildings. But for the most part, in any major city, it's the banks and the insurance companies with their names on the buildings. Yeah, and they know how to make money.
I'm glad you used the word. Another reason I like will, not completely, but it forces people to think about what they're going to do when someone dies. The other experience that dad dies in Australia, has assets.
Yeah.
He even got problems. Which province of those assets?
Mm-hmm.
You think that the bank is all across Canada? No, it's
No. Yeah, it's where it's on deposit, right?
Yeah,
And then,
and we ended up paying over $20,000 in legal.
yeah,
And my dad, a little bit of discussion was fought.
yeah, yeah. And so when you're talking about that cross-border, we see it regularly, Alberta, BC, right, just because of where we are. So you might live in Alberta, die in Alberta, but you've got a place in Kelowna, or you've got a cabin over, whatever, near Dawson Creek. So what happens is you're going to probate here in Alberta first. You can't deal with that asset in BC until it's called a resealing of the probate in that other jurisdiction. So you make the application here, then you make the application here. And you're going to spend more money. And in BC, they've got BC and Ontario have the highest probate fees that you pay to the court in Canada. So BC and Ontario are about 1.5% of the value of the estate, where in Alberta, the highest probate fees you pay to the court for filing your application is $525, regardless of the value of the estate. So, yeah, it can be expensive. And if you don't have that plan, if you don't have that advice for the estate plan, then you just don't know, right? You know, hopefully, if your dad, I mean, did your dad get any advice on that? No, not enough. Yeah, yeah. Right. Right. Oh, wouldn't I have liked to know that, have known that 2 years ago? Yeah. And you won't get that. I mean, you won't get that if you die intestate because you never went to somebody for advice on what you thought you were going to get advice on a document and come away with a document. Well, hopefully you actually get advice on the whole process. This is not a sales pitch, but sometimes, you know, people come and say, well, geez, $1,000, that's a lot. Isn't it just it's just a template, right? You just fill in the blanks. Well, yeah, if I want to get sued, my job is to ask questions and find out specific details so that we can address potential issues, avoid worst-case scenarios if possible. But I can't do that if I charge you $300 instead of $1,000 or whatever, because I don't want to work for free, and that's not. I get cranky if I feel like I'm losing money, and then I just don't put the effort in. But that would be my tendency, right? I'm not gonna do the work if I'm not gonna get paid, but then if I take that attitude, then I'm not gonna give you a good service. I'm not gonna give you the value, give you the advice about the multiple jurisdictions. So, yeah.
Really more than that. He wants me to get along. You go to the intestate, I think you go to just set them up for you. And there's going to be a big fight somewhere.
Definitely the potential for it, yeah. Yeah. Yep. Right. Right. So don't change it on there. Don't scratch stuff out and initial it. Doesn't work. You have to do a new document called a codicil to the original will, or you have to just redo another will. So it used to be the case that wills were handwritten, probably by the scribe or the secretary of the lawyer. And then they were signed by two witnesses, or with two witnesses. So it was kind of a complicated process to redo it. So you didn't want to redo the whole thing, so you did a codicil. This is the first codicil to my will dated January 17th, 1837. And then you said, I don't want the executor to be Joe, I want it to be Paul. Okay, well, that's how you changed it. These days, we have electronic documents. We have Word documents, right? So if you want to change your executor, it's actually faster for us to go, take that document, save as, Paul. Find replace Joe with Paul. And then change it that way. And then, assuming you still have testamentary capacity, the ability to make a will, you just come in and do a new will, and we don't charge you full rate. We might charge you $100 or something. No, We're not Florida. We don't want to give the government all that information on us. Come on. We're pretty frontier still up here. Like a wills registry? I think there are probably, probably BC has a voluntary wills registry. Yeah. Sorry. Just more honest. Okay, what is next here? Okay, so there's a few things that I'm not going to talk about, but I will talk about creditor proofing. And I'll do an amazing diagram. You'll all be extremely impressed. My graphical prowess. Okay, so one of the things that we try and do with the estate planning process is we try and figure out what types of assets you have and whether or not there are some assets that might be better to go around your estate instead of through it, okay? Because when you die, generally, your stuff, if you don't have a named beneficiary or a joint owner on that asset who might have a right of survivorship, the asset's going to go into the estate, okay? So what that means is, like, if Ed is my executor, he's going to hold that house in trust. That's a house. Car. Let's pretend I'm not me and I don't have a wife and 4 kids or anybody else who would have their name on my house or car. It's going to go into my estate. My money is going to go into my estate. It's going to be held by my executor trustee. In trust, remember, for the creditors first, and then beneficiaries, in accordance with the terms of my will. So, we might want our beneficiaries to get stuff out of our estate, but first, the creditors have first dibs before it goes to the beneficiaries. So, we could try and engage in creditor proofing before we die. We could add somebody's name to the title of our house as joint tenant, it's called in Alberta, which would then give that surviving joint tenant the right of survivorship, and it would go around the estate, not through the estate, okay, to the surviving joint tenant. Similarly, with a vehicle, you could do that. With money, you could put it into a joint account with rights of survivorship. With a life insurance policy, you could have a named beneficiary on it. If you don't actively name a beneficiary on a policy, it defaults to your estate. It would go into your estate, be available to creditors or potential creditors before it goes to beneficiaries. So if we can name a beneficiary, we like to name a beneficiary. Similarly with RRSPs. I don't know, can we do that on TFSAs? Name a beneficiary? Yeah, okay. Now, sometimes I have fortunate clients who say, I don't have any creditors. All my debts are paid. And I say, well, that's great, and congratulations, and please teach me how to be better with my own finances. But you can incur creditors on the event of your death. Anybody have any guesses as to how? Funeral home? Canada Revenue Agency. There's a fun one. That's not fun. I think it's fun because I talk about dentists, and I diss the dentist. So if you're in a car accident, and you cause the accident, and you die, and you injure a 30-year-old dentist who's probably making $500,000 a year and is supposed to for the next 30 years of his or her career, that's a $15 million lost wages claim. That's not pain and suffering. That's not the personal injury side of it. That's just the lost income. And your automobile liability policy is probably $2 million. So all your stuff that went into your estate, and you thought that you didn't have any debts, now the dentist gets all of it. Get it? So, to the extent possible, we can, as lawyers, with the help of accountants and tax planners, with the CRA example of a creditor, help creditor proof your estate. Wait, is CRA listening to this? Or is the Dental Association listening to this? Any questions about creditor proofing and why we might? Yeah, well, I mean, the dentist is still going to be injured. I'm not a doctor. But to get around the dentist, you know, if you own a home and you have somebody that you want to give the home to, you can add that person to the title as a joint tenant, and then that asset goes around the dentist, doesn't go to the dentist. Similarly, life insurance, name a beneficiary, RRSP, name a beneficiary, name alternate beneficiaries, just in case the first beneficiary is in the car with you and they die too. Money, joint accounts, yeah. The risk, though, because if this was easy, it would be easy, but it's not. Because there's risk in adding somebody to your title as well. Because maybe that person has a business of their own, and maybe they incur debts of their own, and maybe they get sued and a judgment is against them for owing $100,000, and maybe they find out that that person has a name on the title to a house, and that judgment, the writ, gets registered against your house. So now you are trying to avoid a mythological, hypothetical dentist, and you now have another new creditor that you didn't think you were going to have. So, system, but we try and navigate through it. What time is it, Alan? Holy prenup, Batman. We're going to skip to the prenups. Okay. Prenuptial and cohabitation agreements. Prenuptial agreement refers to an agreement that you make before you get married to deal with how you want things to end up on a breakdown of that marriage with respect to, generally, matrimonial property. So property that you incur during the course of the marriage, and how you might want to have spousal support or alimony dealt with on the breakdown of the relationship, and potentially child support. But usually we're just dealing with the first two, property and spousal support. So I'm going to skip to the third question there. What are we usually trying to accomplish with these agreements? Again, we're trying to figure out what is to happen on the breakdown of the relationship. Probably to clarify at the outset what's going to happen, and then to minimize, hopefully, the legal disagreements and the very expensive nature of family law litigation. So, if we know ahead of time what the outcome is going to be If we separate or get divorced, then hopefully we won't fight too much about it after. So, matrimonial property. So, matrimonial property, I guess in order to understand prenup and cohabitation agreements, you kind of have to understand what property we're talking about. So matrimonial property, I keep saying matrimonial property, but earlier in 2020, the government changed the Matrimonial Property Act to now it's called the Family Property Act, and they've now included common law spouses or adult interdependent partners into that. So now an AIP, an adult interdependent partner, now has same rights as a married person with respect to family or matrimonial property. So if I say matrimonial property, I now really mean family property, but it's the same thing. So I'm just used to saying matrimonial property. Matrimonial property is all property that is acquired by either party, husband or wife, spouse, I guess, at any time after the marriage. Okay? Date of marriage. Okay? So this stuff is exempt. Exempt. Okay? So the Lamborghini that you owned before the marriage should still be yours after the marriage, even without a prenup. But if you have a prenup, then you've already identified that, yeah, that was my Lamborghini. You don't have to fight about it. So matrimonial property is all property after the date of marriage acquired by either party. And the increase of exempt property that occurs during the relationship. So if the Lamborghini increased in value during that time frame, then the increase, the part of the value that's the increase from this date to the, we'll just, for simplicity, we'll say date of separation or date of divorce. Okay, so increase in the exempt property. In order to understand that, you have to understand the different exemptions. So we'll say pre-relationship property. We'll say inter vivos gifts / inheritance. I can't remember if it's ENCE or ANCE. So inter vivos means during lifetime. So inheritance would be like, hey, dad died and left me the farm. Inter vivos would be, hey, dad had a midlife crisis, realized he didn't want the farm, and gave it to me while he was still alive. Okay? 3, what's personal injury? Can't remember. Personal injury awards. So you get in a car accident, you break your back, you get a $250,000 settlement. That money is exempt because your spouse didn't feel the same pain that you did. Yep.
Prior to the marriage. Then the couple are married. Then the parent dies, and you inherit the farm. Because the farm existed prior to the marriage, that's considered exempt.
So it's considered exempt because it's inheritance. So even if that happens here, inheritance, that farm is exempt. If you owned the farm here, it's exempt, or if you inherited it here, it's exempt. Or, you inherited it prior and you owned it. So, does that?
Then is the argument used, inherited, now you've inherited.
Yep.
Any gain, then we're back.
From here.
We have to.
Yeah. Yeah. So any gain on exempt property, whether it's pre-marital property. That sounded dirty. Like I just said on the internet. Whether it's a property you owned before the marriage or whether it's exempt for these other reasons. If it's an inter vivos gift or an inheritance or a personal injury award, maybe there's a car accident here, then the increase in the value on that settlement from that point until the date of separation or date of divorce is then considered matrimonial property. Make sense? Super easy, right? Who wants to come to work with me tomorrow? What's that? Yeah. So this is like crash course matrimonial property law. So at the proper date of valuation, whatever the court decides that for that to be in that case, which is at first glance the date of divorce or the date of trial, but quite often in settlements we're using date of separation. So depending on which date we use as the date of valuation, we're looking at the value, so the net between gross matrimonial property and the matrimonial debts. Yeah. Okay, so kind of have a little bit of an understanding of matrimonial property. Then we go back to the prenup and say, how are we going to divide all this stuff? Trying to make a decision beforehand. Quite often, if people are coming to me or to other, I don't really do family law, but I used to, so I understand this. If people are coming to me for this kind of thing, you already kind of have a sense like they don't want to share the stuff after, right? So it's usually, we don't want to share the stuff after, and that's what the agreement says. Whatever I have, whatever I came in with, and whatever increase in value on those exempt assets or any increase in value on inheritance or any increase in value on personal injury awards, I keep. My stuff is mine, your stuff is yours, and then it's kind of a toss-up on the spousal support. Some people I would see, you know what, my property is my property, your property is your property, but if we get divorced, you're going to pay me X percentage of what a normal settlement would be for spousal support. Yep. Yeah, child support is easy because there's the federal child support guidelines, which are actually not guidelines. They're mandatory. And it's based on income. It's based on the income of the person paying and the number of kids and the jurisdiction in which the payor lives. So it's like, where does, I'm going to say the dude, because usually he's paying, live? Okay, find that Manitoba table. How many kids? 3. What's his income? Well, then it sometimes we try and fight over, well, what's his income? Because maybe he's got a company and maybe he's not paying himself full wages, but maybe the company's buying him groceries and maybe he's got a cell phone that the company pays for and the truck and the fuel and so. If there's ever a fight on child support, it's what's the guy's income. Okay, so that's generally easier than spousal support. Because there's also the spousal support advisory guidelines. And those are guidelines, except that some courts have looked at them and said, no, they seem pretty good, we're going to use that formula. So when you're talking about spousal support, first you got to consider whether or not there's entitlement. That's the first question. Usually, if people are living together in either a common law relationship or a marriage, and the relationship breaks down, then the person who is most financially disadvantaged from the breakdown of the relationship is going to be entitled to support. So we often just overlook the question of whether or not there's entitlement because there's entitlement. Once you find entitlement, then the court would have to determine quantum and duration. So how much and for how long. And that's where it kind of gets gray. Because it used to be that courts looked at means versus needs, the means of one party to pay and the needs of the other party. And then it got into what the industry, what the profession called the battle of the budgets. Because, okay, well, how do we know what the means of this person are to pay, and how do we know what the needs are? Well, everybody does budgets. And, I mean, budgets can become creative. So, because this was not a satisfactory system, in Ontario, the bunch of lawyers and judges got together and created the Spousal Support Advisory Guidelines. So now there's a formula. There's a formula that you can use where there are children of the relationship, and there's a formula that you can use where there are no children of the relationship. And the reason there's two different systems is because if there's children, then chances are there's child support being paid. And child support is not a taxable benefit and not tax deductible, but spousal support is. And it becomes very complicated because now you're talking about what's your income, what's the combined net family income after spousal support, because you kind of have to build it in and calculate the projected tax consequence as well, because we're looking at net disposable income for each. And then, so ultimately, here's like what it boils down to. Net income for the person for the person receiving should be somewhere between 40 and 46% of the net, okay? And so whether they've got kids or no kids, 40 to 60%. Because if you make the person who's paying pay more of their income, their net disposable income, to the other person, then that is very demoralizing to this person. And this person stops trying. That makes sense? Like, I gotta have at least 50%, hopefully 60%. But if I'm paying you more than I'm actually getting at the end of the day, then I'm just gonna fall asleep under it, I don't know, in a dark hole somewhere and not go to work and not like anything in life. Probably in a bad way already. This got dark very quickly. Yep. Right.
A lot of it seems to be legal fight, where relationships break down, there's no settlement, and then it goes on year after year after year.
Yeah.
You don't come to the settlement. In these agreements, is there a way to sort of force settlement, where someone can't say, well, I think this is unfair, so I'm just going to hold out and blackmail you for the next 5 years or whatever? Is that impossible to do?
Yeah, you can put an arbitration clause in. Say arbitration because a couple of reasons. Arbitration's like private court. So it's like you hire an arbitrator and you pay them to listen to you and to make a decision. And then hopefully it's binding arbitration as opposed to non-binding arbitration. So then that's the decision, and that's what happens. Arbitration is expensive because you have to pay for the judge and you have to pay for whatever the process is if you're hiring a lawyer. But it can be much faster. So like in the States, everything happens way faster. Litigation happens way faster there. Like here, you want to go to court on something, it's going to take you 3 years to go to a trial. But on suits, they can do it in a day.
That's because they work all night long.
I know.
It's always dark.
Yeah.
The idea here is
Right. What are you going to fight about? That's my stuff. I already identified it as my stuff. The agreement says if it's in my name, it's mine. So, yeah, you can fight about it, but you're going to lose, and you're going to pay my legal fees. I mean, another, whether or not you've got a prenup, mediation in certain circumstances can be helpful. I don't really do that much family law really anymore, but I do still do family law mediations. So where for the first 5 years of my practice, probably 30% of my work was family law, and I really got to hate it because nobody's ever happy with you, right? The other lawyer hates you. Your client hates you. The other spouse hates you. So if you were looking for your value in that, you weren't going to find it. But so something that takes 3 or 4 years is really wearing, even on somebody whose life it shouldn't affect. So the longer it takes, like the less motivated I am to deal with it because I'm frustrated because you guys aren't figuring this out. What's the big problem? Well, so that's litigation. Mediation, I bring in husband and wife. I look at all their financial stuff. I get all their financial stuff ahead of time. I look at it all. And then in a day, like I teach them matrimonial property. I teach them spousal support law. I teach them child support law. They listen. They see the other person hearing the same information. And then we apply their situation to the law that we just taught them. And when they saw the other person hear the same information, it becomes very difficult for them to be unreasonable. But in the litigation scenario, it's like the game of telephone, right? It's, okay, Tim, I really want $100,000. Okay, all right, whatever. So then I go and I kind of feel like I want to be a hero for this person, so I'm go and maybe I say, well, we want $110,000 or whatever. Or sorry, maybe it's this. Maybe I give them a range. Maybe I'm working for the wife, and she's trying to get, in my impartial mind, my reading of the law, I say, she's probably entitled to 80 to maybe 100, but probably 80. And then I tell her, no, we could probably get you 100 because I want to be a hero, right? And that's not appropriate for me to do, but maybe I'm human, so I just give that higher end of the range. 100. So she hears 100. Then over here, the husband's lawyer says, you know what? In his mind, her mind, he says, it's probably 80. maybe we could get away with 70, maybe we could get away with 60. So then she tells her husband client, you're not going to have to pay $1 more than 60. Well, now we've got entrenched positions based on authoritative advice by the lawyers that I'm not going to have to pay more than 60, and I shouldn't accept $1 less than 100. So now we got a problem. And then there's the game of telephone where so-and-so, okay, yeah. So I understand 80% of the message coming from my client, and then I communicate it to the other lawyer, and that other lawyer understands 80% of my message, which was only 80% of her message, and so on. And then we have 80% of 80% of 80%, and over here, and then he blows up. He's like, what? And then she gets a text message and a telephone call, and it just exacerbates the problem. So, yeah, if you've got an agreement ahead of time, it could help matters after the fact. I don't like them personally, because I think you're planning to fail. That being said, 50% of them fail. So, and by them, I mean marriages. I mean, I don't know what the stats are these days. Do you know, Alan? Yeah, so if you make it past 7, I guess you're doing well, or you're cranky.
And he told me that every file he looked at, every 2 months, he charged money for that.
Mm-hmm.
I looked at the number of files he had, he was making a good living. I suspect, I don't know if it's true, that a lot of lawyers don't want to sell. Part of the problem is, not only are the two people fighting,
Yeah.
but they're not being helped by the professional. I mean, sometimes you're lucky to get a good divorce lawyer that does make a deal and
Yeah.
very bad system.
Yeah.
There's some bad actors there.
Sure. Agreed. Yeah. Which is why I like the mediation, because in a day we can get it done. Go through everything. Boom. A week later, I have an agreement drafted. And it's not going to take 4 years, 3 years, 2 years. Maybe it's not perfect, but you move on. Any questions? I'm about done.